Welcome back to the Deep Dive. Today we are wading, well, pretty deep into a fascinating bit of intellectual property law. It's really about where the sort of rigid rules of getting a patent crash into the messy reality of academic publishing.
Yeah, it's one of those things we often take for granted, isn't it? You write something down, it's out there. But legally, that jump from, say, a student's thesis just sitting somewhere to something the law says everyone could have found, that's tricky territory.
And that transition, that specific point, is really the heart of what we're digging into today.
Absolutely. Think of it like a patent detective story. We're hunting for a date stamp, basically. We're going to unpack a legal fight in re Leo M. Hall that pretty much all came down to how one German university library handled a PhD thesis almost 10 years before the patent application we're talking about was even filed.
Right. So our mission today is to cut through the legal speak, the jargon, in re Hall and figure out exactly when academic work, like that thesis, becomes official prior art. Because if that dissertation counts as a, quote, printed publication, even one day too early, specifically if it was accessible before February 27, 1978, well, Hall's patent claims, they're gone, invalidated.
The stakes were huge. And the whole thing, it really boils down to defining this one concept. What does public accessibility actually mean in the eyes of the law?
And maybe even more specifically, right, how much proof do you need? Especially when you're talking about, like, the regular mail handling routines of a library overseas decades ago.
Exactly. That's the tension. That's what we need to explore for you today.
Okay, let's lay the groundwork here. Before we get into the arguments, which are complex, we need to get the basic facts straight. The who, what, when, where, hashtag, tag 1.1, case identity and parties, Q1.
All right. So the case itself is in re Leo M. Hayes. The citation, if you want to look it up, is 781 F.2D 897. You'll also see it as 228 U.S.C. 453. And importantly, this comes from the United States Court of Appeals for the Federal Circuit.
The Federal Circuit. That's significant in patent law, isn't it? In fact, maybe just remind us quickly why their decisions carry so much weight.
Oh, absolutely. The Federal Circuit has exclusive nationwide jurisdiction over patent appeals. So appeals coming from the Patent and Trademark Office, the PTO, they go straight there, which means their rulings basically set the standard for patent law across the whole country. This particular judgment, it was handed down January 16th, 1986.
Okay. And the judges involved?
The opinion we're dissecting was written by Circuit Judge Baldwin. Sitting with him were Senior Circuit Judge Nichols and Circuit Judge Kashiwa. And there's a little note in the case, Judge Kashiwa participated fully, but he actually retired just a few days before the decision was formally issued on January 7th, 1986.
Interesting detail. Now, the parties involved. We've got the person wanting the patent, Leo M. Hall, and then the PTO pushing back. Who are their lawyers?
Right. So the appellant, Leo M. Hall, he was trying to get a reissue of a patent application. His lawyers were John F. Farrow and Boris Haskell. And arguing for the appellee, the U.S. Patent and Trademark Office, you had Freddie McKelvey, Joseph F. Nakamura, and Michael L. Gellner representing the PTO's side. It's always interesting in these cases, seeing the PTO defending its examination process against an applicant. Hashtag, tag 1.2, key facts, and timeline, Q2.
Okay, now the timeline. This is absolutely critical, isn't it? It really shows how sometimes just a few weeks can make all the difference. When did Hall file, and what's the key date we need to keep in mind?
So Hall filed this specific reissue application, number 343,922, on January 29th, 1982. But for what we call the statutory bar, the prior art deadline, we actually look back to the effective filing date of his original application, and that date was February 27th, 1979.
February 27, 79. Okay, so that means we're dealing with the one-year prior art rule from the patent statute, 35 U.S.C., section 102B. That sets our cutoff.
Exactly. The rule says you can't get a patent if the invention was described in a printed publication more than 1 year before you filed. So you take that February 27, 1979 date, go back exactly 1 year, and that gives you the critical date. February 27, 1978. If the prior art we're talking about was publicly accessible before that date, even by 1 day, Hall's patent is barred. Everything hangs on that date.
And the prior art here, it wasn't another patent or a product, it was academic work, right? A thesis.
That's right. It was a doctoral dissertation by a researcher named Peter Foldi. The title was something like One Buller for a Glucohydrolase and Amylotylysis Enzyme. It was German. It was submitted to Freiburg University in what was then the Federal Republic of Germany. And crucially, this thesis described things that were basically the same as or made obvious what Hall was trying to patent.
Okay, let's map the timeline for that thesis against Hall's February 78 critical date. When did it actually move through the university system?
Yeah. All right, so Foldi submitted the dissertation itself in September 1977. He got his doctorate officially awarded on November 2nd, 1977. Then, just 2 days later, November 4th, 1977, the official library copies arrived at the university library from the faculty. So that's when the physical documents hit the library's intake.
So they're physically in the library building in early November 77. But when did the library actually say people could, access them, read them?
Well, that's the million-dollar question, isn't it? That's the whole dispute. The library director, Dr. Eric Will, he provided these crucial affidavits. And he stated that, based on how they normally process things, the dissertation most probably was available for general use toward the beginning of the month of December 1977.
December 1977. Okay, so if that estimate holds, that gives the PTO, about 2.5 months, from early December 77 until the critical date, February 27, 78. That's their window?
That's their window, exactly. That cushion is basically the PTO's entire argument on this point.
And didn't Hall make some kind of concession that narrowed things down even more?
Yes, this is really important. Hall conceded upfront that yes, his claims were unpatentable if the Foldi thesis counts as a printed publication available before that critical date. So they weren't arguing about the science, whether the thesis actually anticipated his invention. They basically said, okay, if you can prove it was public before Feb 78, we lose. It turned the whole thing into purely a fight about library procedures and timing. Was it accessible? Yes or no? Hashtag tag 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 1.3, the legal issue, Q3.
Right. So it simplifies things in one way, but makes that one remaining question incredibly important. What's the specific law here, and what was the precise question the Federal Circuit had to answer?
The law is 35 U.S.C. Section 102B. That's the statute that lays out this one-year bar. It says you can't patent something if the invention was. And here's the key phrase. Patented or described in a printed publication in this or a foreign country more than 1 year prior to the date of the application.
Printed publication. That sounds simple, like ink on paper, but in patent law, it means more, doesn't it? It's about accessibility.
Exactly. It's a legal term of art. It doesn't just mean physically printed. It means it has to be sufficiently disseminated or accessible to the relevant public, people interested in that technology. And here, you've got a few complicating factors. One, it's a doctoral thesis, potentially pretty niche. Two, it's in Germany, a foreign country. Three, you've got this very specific deadline. So the core legal question for the court was this Foldi thesis sitting there in the Freiburg University library accessible enough to the public specifically, people interested in enzyme technology before February 27th, 1978, to legally qualify as a printed publication under Section 102B?
Wow. Trying to prove the exact status of one paper in a foreign library decades ago. That sounds like a tall order.
It absolutely is. And that difficulty, that challenge of proof, is exactly what Hall's lawyers tried to leverage.
Okay, so this is where it gets really interesting. Hall's team isn't saying the thesis didn't exist. They're saying the PTO couldn't prove it was findable in time. It's like the battle of the library card catalog. Hashtag tag take 2.1. The applicant's arguments. Hall,
Okay.
Q4.
Right. Hall's whole strategy was basically to set the bar for accessibility incredibly high.
How did they define that? What was their standard?
Well, their main argument, the strongest one, was all about indexing. They said, look, accessibility is the legal touchstone. That's the key. A document might physically exist somewhere, but if the public can't reasonably find it using, the normal tools like a catalog, then it's not effectively public, it's hidden.
That makes intuitive sense, doesn't it? I mean, today
Yeah.
we'd say if you can't Google it, it might as well not exist. Back then, the library catalog was the Google.
Exactly. So Hall argued the PTO hadn't shown any concrete proof, like documentation, that this specific dissertation was actually indexed or cataloged properly in the library's public system before that February 1978 date. Just having it physically present in the library, maybe sitting on a shelf waiting to be processed. Hall said that's not enough to block a U.S. patent. Without proof of indexing by the deadline, the PTO hadn't met their initial burden.
So the argument was, no dated proof the catalog card was filed means the PTO's case fails. That seems like a pretty strong point, given how libraries work, or used to work.
It was a strong point. Then Hall had a second argument, kind of related. This one was about the reach, the scope of accessibility. He argued that even if, hypothetically, it was cataloged, just having one single copy of a thesis cataloged in one university library in Freiburg, Germany, well, that's still not accessible enough. Not accessible enough for people skilled in the arts, like enzyme chemists, probably mostly in the U.S., exercising reasonable diligence. He was questioning if that one German library copy really put the world on notice.
And they pointed to another case to back this up, didn't they? In Red Bear. Why was that case so important for Hall's argument?
Bayer, yes. Bayer was Hall's perfect precedent, or so he hoped. In the Bayer case, the court looked at a very similar situation, another dissertation. But crucially, the evidence in that case showed that the library's process for cataloging and shelving routinely took months, many months. And even more importantly, the evidence showed that during that processing time, the theses were kept in a private office. They were physically inaccessible to the public until they were officially shelved and cataloged.
Ah, okay. So in Bayer, the court actually found evidence of inaccessibility during processing. And Hall was trying to say, see, you need specific proof it wasn't inaccessible here too.
Precisely. Hall used Bayer to argue that the PTO needed to produce hard evidence like date stamps, log entries, something specific, proving the Foldi thesis was moved out of any potential processing limbo and into the public catalog before the critical date. He wanted that same high standard of proof applied. Hashtag tag tag 2.2, the board's findings and counter-arguments, Q5.
So how did the PTO board react to that? To Hall demanding essentially a specific date stamp from a German library from 1977. They must have thought that was asking a bit much.
They did, basically. The PTO board upheld the rejection of Hall's patent. They argued that the evidence they did have was enough. It was persuasive. Their key counter-argument wasn't about finding a specific date stamp, but about relying on evidence of the library's routine business practice.
Routine business practice. Okay, tell us more about that. And this ties back to the library director's statements, right? Dr. Will's affidavits.
Exactly. Dr. Eric Will, the director of the loan department at Freiburg University Library, his testimony in those affidavits was absolutely central to the PTO's case. The board relied on him for two main things. First, just basic facts. Yes, the library got the copies on November 4th, 1977, but second, and this was the clincher, he gave a detailed description of the routine way the library handled dissertations as part of its normal operations.
So even if they couldn't find the one specific index card for Foldi's thesis from that week, they could show how all the instances were handled.
That was the argument. Dr. Will stated that once they received these copies, they were, quote, freely made available to the faculty and student body of Freiburg University, as well as to the general public. And crucially, he testified that these dissertations were indexed in a special dissertation catalog, but that catalog was part of the main user's catalog, so you could find it using the standard library search tools. It wasn't hidden away.
Okay, and how did Dr. Will connect that routine practice back to the timeline? to that December 1977 estimate?
Based on this standard procedure, how long things usually took, his consistent estimate was that Foldi's dissertation most probably was available for general use toward the beginning of the month of December 1977. So the PTO argued, look, we have testimony about a reliable routine process. That process leads to an availability date in early December 77. That's a good 2.5 months before the critical date in February 78. That constitutes a strong prima facie case of public accessibility. The routine itself provides the evidence.
Right, so this really sets up the core legal question for the appeals court. Does evidence of a reliable routine trump the demand for specific dated proof?
That's exactly what the Federal Circuit had to decide. Can routine practice evidence be strong enough to invalidate a patent claim?
All right, this is the real deep dive section. The Federal Circuit's decision here essentially set the standard for how we verify academic prior art in the U.S. patent system. Big implications. Hashtag 3.1, the court's decision and holding Q6.
Okay, so the bottom line first. The Federal Circuit affirmed the board's decision. They agreed with the PTO. They held that Leo M. Hall's claims were unpatentable because of that prior art bar in Section 102B.
And the specific legal finding that got them there.
The court found that the evidence the PTO put forward, especially Dr. Will's affidavits about the library's routine, was enough to establish what's called a prima facie case. A prima facie case means, basically, the PTO presented enough evidence that, on its face, suggests the thesis was a publication before the critical date. And this is key. The court found that this prima facie case stood unrebutted by Hall.
Unrebutted. Let's pause on that. For listeners maybe not deep in legal terms, what's the significance of the case being unrebutted?
It means that once the PTO presented enough evidence to make a believable initial case, the prima facie case, the legal burden, the responsibility shifted. It shifted over to Hall. He then had to come forward with actual evidence to contradict the PTO's case. Evidence showing that, no, despite the library's normal routine, this specific thesis was somehow delayed or inaccessible during that crucial window from December 77 to February 78.
And he didn't provide that counter evidence. He just kept arguing the PTO's evidence wasn't good enough in the first place.
Exactly. He challenged the type of evidence, routine practice, instead of challenging the facts presented by that evidence. The court basically said the PTO showed it was likely public based on their normal process. You haven't given us any reason to believe they didn't follow their normal process this time. That was the crucial failure in Hall's argument. Hashtag 3.2, thorough analysis of the reasoning, Q7.
Okay, so let's get into the why. Why did the court accept this routine business practice evidence? It feels a bit estimated, maybe, when patent rights are on the line.
Well, the court started by going back to basics. What's the whole point of Section 102B? It's to make sure things already in the public domain stay there. You can't pull knowledge back out of the public sphere and lock it up with a patent. And to figure out if something is in the public domain, the touchstone, the absolute key is accessibility. The PTO, as the party challenging the patent, has to show the reference was, quote, sufficiently accessible, at least to the public interested in the art.
Accessible enough that someone in the field could find it and understand the invention from it.
Right. And this is where the court directly addressed Hall's heavy reliance on the In re Bayer case.
How did they handle that? Because Bayer seemed to support Hall's demand for specific proof.
They distinguished it very carefully. The court agreed with the board that the facts in Bayer were just different. In Bayer, the librarian's testimony actually proved the thesis was inaccessible for a time. Remember, it was stuck in a private office. So the evidence itself showed a lack of access during the critical period. The applicant in Bayer successfully rebutted any presumption of accessibility.
But here, in Hall, the librarian's testimony pointed the other way, towards accessibility.
Exactly. Dr. Will's affidavits consistently described a process designed to make dissertations available freely and routinely. This brings us to the core legal move the court made. They essentially acknowledged the practical reality, getting ironclad, specific documentation about the handling of one specific paper decades ago from a foreign library. That's often impossible. If they insisted on that kind of proof, the Section 102B bar would become almost useless for a lot of older foreign or academic publications.
Okay, I'm still kind of grappling with this a bit. Why should the U.S. patent system care so much about the administrative efficiency of a German library in 1977? Why not demand the hard proof?
That's a fair question. And the court's answer is really the central point of this case. They formally established that routine business practice is competent evidence in this context. This is the legal innovation of In re Hall. The court explicitly said you do not need direct evidence proving the specific date of cataloging and shelving before the critical date. Requiring that, they recognized, would often be an impossible standard and would undermine the whole purpose of keeping public knowledge public.
Where did they find the legal justification for relying on routine? Is that common in other areas of law?
Yes. It is. They pointed to established principles in the law of evidence. They cited authorities like Wigmore on evidence, a classic legal text, and also Rule 406 of the Federal Rules of Evidence. Rule 406 specifically allows evidence of the habit of a person or the routine practice of an organization to prove that their conduct on a particular occasion was in conformity with that habit or routine.
Okay, so it's like saying, because the library always did X, we can legally infer they did X this time too, unless someone proves otherwise.
That's exactly the inference they allowed. They found Dr. Will's description of the library's general practice, leading to that estimate of availability toward the beginning of the month of December 1977, to be competent and persuasive. The fact that this estimate gave them a 2.5-month buffer before the critical date also helped. It wasn't cutting it super close. If the estimate had been, say, February 26, 1978, maybe the court would have hesitated more. But with months to spare, the routine evidence was strong enough.
And what about Hall's other point?
Yeah.
That just one copy in one German library wasn't really accessible enough to U.S. researchers.
The court pretty much shut that down. They rejected the single library argument. They stress that accessibility is judged case by case based on the facts. If a library makes its collection available to its public, which includes faculty, students, visiting scholars, the general public in that area, through standard means like catalogs, then it's considered publicly accessible for patent law purposes. The law doesn't demand proof that people actually found it or read it, just that they could have found it with reasonable effort using the established systems.
So it's the opportunity for access, made possible by the library's systems and routines, not proof of actual access.
Correct. The court decided the evidence of the routine cataloging, the public nature of the catalog, and Dr. Will's testimony about free availability was sufficient proof that the opportunity existed well before Hall's critical date. Hashtag 3.3 statutes and precedents relied upon, Q8. So just to quickly recap the main legal building blocks the court used here.
Obviously, the statute itself is the foundation.
Absolutely. 35 U.S.C. Section 102B, the one-year printed publication bar. That's the bedrock. But then, to interpret what printed publication and accessibility mean in practice, they leaned on a few key prior cases or precedents.
Which ones were most important?
Well, they mentioned In re Wire. That case helped establish that printed publication isn't stuck in the past. It evolves with technology. It confirmed that things like microfilm or potentially even early databases could count, not just mass-printed books. It's about dissemination and retrieval.
So the format wasn't the issue. It was whether people could get to the information.
Right. Then they cited In re Donahue. That case underscored the requirement that the publication has to be enabling, meaning someone skilled in the field could read it and actually make the invention without needing significant further research. The Foldi thesis apparently met that standard.
And Bayer, of course, even though they distinguished it.
Yes. In re Bayer was crucial, but in a different way. Bayer helped define what isn't accessible, like being locked away during processing. It set a high bar for what accessibility means. But Hall then provided the answer for how you prove accessibility when specific records are missing. Hall says, you can use evidence of reliable routine practice. So Bayer sets the standard. Hall clarifies the type of evidence you can use to meet or fail to meet that standard, especially when dealing with institutional processes.
Just quickly on the judges themselves, was this a close call? Was there disagreement on the panel?
It seems not. The opinion reads as unanimous. The published decision doesn't mention any dissenting opinions where a judge disagrees with the outcome, or concurring opinions where a judge agrees but for different reasons. It looks like Judges Baldwin, Nichols, and Kashiwa were all on the same page.
What does that unanimity tell us, big picture, about the legal principle they established?
Well, it suggests a pretty strong consensus within the Federal Circuit, the key patent court, that this approach was necessary and correct. They likely recognize the practical problem. If you can't rely on evidence of routine practice, enforcing the prior art bar against many older or foreign academic works becomes almost impossible. So the unanimity signals a solid backing for the idea that protecting the public domain sometimes requires accepting this kind of evidence, provided it's credible and, crucially, unrebutted. It's cemented routine practice as a valid tool. Hashtag 4.2, legal significance and precedential value, Q10.
Okay, so we have the In re Fall standard now. What's the immediate practical impact? What changed for the PTO and for inventors after this 1986 decision?
Two main things, really. First, Hall explicitly gave the PTO the green light to establish that initial prima facie case of public accessibility using evidence of routine institutional practice. Things like librarian affidavits describing normal procedures, that's now officially competent evidence, even without a specific date stamp for the document in question. And second, it really clarified and arguably strengthened the burden shift. Once the PTO makes that initial showing based on routine, the burden lands squarely and heavily on the patent applicant. The applicant must then produce specific evidence showing why that routine wasn't followed or why the document was actually inaccessible in their specific case. Hall lost because he attacked the method of proof, not the substance of the librarian's testimony about the routine itself.
So for the academics, the researchers, the inventors listening, what's the takeaway for them in their daily work? How does this affect them?
For you, if you're doing research or inventing, this case is basically a huge warning sign about publication timing. It means any academic work, a thesis, maybe even a conference presentation abstract, if it's properly archived and accessible, a report filed with a library as soon as it enters an institution system and is findable through their normal routine methods that can start your one-year patent clock. The clock likely starts ticking the moment it's findable via those established channels, not necessarily the day someone physically pulls it off a shelf or downloads the PDF. Early filing becomes even more critical.
And you think about today, with digital repositories, online journals, university archives that are instantly searchable worldwide, that accessibility happens almost immediately now, doesn't it?
It really does. You could argue this 1986 decision, based on physical library processes, actually laid the logical groundwork for handling instantaneous digital publication as prior art today. If a paper goes into an indexed, searchable online university database, it's arguably far more accessible than Foldi's thesis was in Freiburg in 1977. Hall makes it easier for the PTO to argue that such digital availability constitutes a printed publication almost instantly. Hashtag 4.3, the most important takeaway, Q11.
Okay, let's boil this all down. If someone remembers just one thing from our deep dive into library procedures and patent law today, what's the single most important takeaway from In re Hall?
I think the absolute core takeaway is this. Patent law accepts evidence of established routine administrative processes, even at a foreign library, as legally sufficient proof of public accessibility, unless proven otherwise. You don't always need the specific date stamp or the smoking gun index card. Competent testimony about a regular, reliable system for making documents available can be enough to show something entered the public domain, especially if that testimony points to availability well before the critical date, and this is vital. The patent applicant doesn't provide concrete evidence to contradict it. The routine can beat the demand for specific proof, shifting the burden heavily onto the inventor to prove inaccessibility. It underscores the need to file patent applications before any kind of public disclosure, however seemingly obscure. Hashtag tech outro.
Well, that was a really fascinating look at how the small details of administration in this case, how efficiently a German university library processed dissertations back in the 70s, ended up deciding the fate of a U.S. patent. It wasn't a missing scientific link that sank Hall's patent. It was the established, documented, and legally accepted routine of the Freiburg University library.
It really was. And thinking forward, connecting this 1986 case to today, it raises some big questions, doesn't it? Back then, we needed affidavits about physical handling, cataloging, shelving. Now, academic work often appears online, globally indexed, almost instantaneously. The physical processing lag has vanished.
So how does the Hall standard, which relied on proving a process that took time, apply now?
Well, that's the provocative thought, isn't it? Does instant digital publication just make the Hall analysis simpler? Accessibility is immediate upon upload to a searchable site. Or does the legal fight just shift? Maybe now the arguments are about. Was the database truly searchable by the public? Was the indexing adequate under the spirit of Hall? What counts as a sufficiently accessible digital publication? It's something for you to definitely think about as you navigate the world of intellectual property, where the definition of public is constantly evolving with technology.